All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State, appearances for the record.
Chief Fisher on behalf of the state.
William J.
Defense.
James Owens for Sarah Boone.
Tony Henderson for Sarah Boone.
All right, Ms. Boone is seated at counsel's table wearing the same clothing from earlier this morning. All right, it is 11:24. With regard to the Richardson hearing with regard to item 6 in the defendant's fifth amended reciprocal discovery list, the court is going to reserve and have that hearing tomorrow morning at 9 a.m. Defense is to provide an edited version of only the records that pertain to anxiety or their lack of thereof to the state before 9 a.m. tomorrow morning.
Judge, number 6 was cured by agreement.
Okay. Did that happen when I was not here?
No, it happened earlier while we were here.
Then what specifically was the Richardson violation for then, if it wasn't for number 6? And I apologize.
I think it was for number 2 was the 119 new JPEG pages, reporting to be from Winter Park Advent Health, and they're a little bit different than the 81 pages that I previously received.
Okay. So the ruling remains the same. Court's going to reserve, address the Richardson hearing tomorrow, and you were to provide an edited version of those records that you seek to offer into evidence. Mr. Owens, before 9 a.m. tomorrow morning.
Regarding the paragraph number 2, regarding the Winter Park Advent Health records, the 119 that we gave him this morning.
That is correct, sir. With regard to the witnesses that have been identified by the defense in paragraph 60 of the state's response, those witnesses will be excluded if not deposed prior to being called as witnesses, and the defense shall pay for any and all expedited transcripts.
All right, Judge, the same as should apply to them. There were 3 people that they gave us late that we didn't have before: Rachel Fenner, Meredith McCaskill, and Victoria Shelton.
State response.
Meredith McCaskill is an FDLE analyst that is substituting for an analyst that is unavailable during the trial period. So in an effort to not continue the case, we got a substitute analyst. So that's our reason for the late disclosure on her. And who were the other 2?
Michelle Fenner and Victoria Shelton.
And those are the 911 dispatchers. Mr. Cacciatore does not believe that the defendant ever deposed that person.
Okay. Any other positions, Mr. Owens? Okay. All right. State will afford the same opportunity to the defense as provided by the state to the defense. Court's going to be in recess. It's 11:27. Hang on. Juror number. Yes, let me address that. Can I have the thing again, please? If you all still have yesterday's sheets from jury selection, Madam Clerk has advised that jury services has told us the juror in seat 25 wearing badge 63 called sick child. The nephew that she cares for is ill and that she is not here due to caring for that child. He is not here due to caring for that child. State's response, if any.
For cause.
So stipulated, juror number 25 wearing badge 63 will be struck for cause. We'll advise the jury services to call them and tell them they do not need to report. With regard to the Order Tennis motion as to Ms. Boone's request for snacks, the Order Tennis motion is denied. Ms. Boone is being provided all the same services as to any other inmate being transported for the purposes for trial. Anything else we need to address, State, before we report back to 23 at 1 p.m.? Defense?
No, sir.
All right, we'll see you all at 1 p.m. Thank you very much. Court's off the record. All right, thank you, counsels. Defense counsel, if you could see to address those matters that we discussed, I would appreciate it. Anything else we need to address before we bring in our panel?
No, sir.
Defense. All right, let's stand and bring in our panel. Thank you.
The green light on. Shelby, hand me my CD. Thank you.
State, do you recognize our panel? Defense, do you recognize our panel?
Yes, Your Honor.
All right, thank you all. You all can be seated. Members of the jury, thank you again for your time. Welcome again to 23 Alpha of the Orange County Courthouse. My name is Judge Michael Kranick, and again, I will be the presiding judge in the case of the state of Florida versus Sarah Boone. I am going to ask the state to introduce themselves again to you this afternoon.
Good afternoon. Dave Cacciatore, Assistant State Attorney.
William J., Assistant State Attorney.
And defense, if you could introduce yourself and your client, please.
I'm James Owens, and I represent Sarah Boone.
Tony Henderson, representing Sarah Boone.
Kevin Beck on behalf of Sarah Boone.
Shelby Andrews, jury selection and trial consultant.
Lauren Henderson, assisting the defense.
Thank you all. You can be seated. Now, members of the jury, yesterday evening around 5:15, I gave you an instruction. If you could please raise your paddles to show that you complied with the court's instructions in this case. Record will reflect all paddles have been raised. Now, members of the jury, I want to take a moment again to thank you. Yes, sir. Juror number 26. Juror number 39? Did you follow the court's instructions? By you were able to hear the news yesterday, what does that mean?
I'm sorry. She needs a
Can we get her a microphone, please, for Madam Court Reporter? Thank you. Juror number 8, I appreciate you. Yes, ma'am.
I was at my parents' house yesterday evening, and they keep the news on, and I was in the other room, and I overheard it.
Okay. Did you overhear anything pertaining to this case?
Yes, I did.
Okay. Can the parties approach for a moment? Actually, just hold that thought. Ma'am, just hang on for me. We may have some follow-up with you individually. First, I want to take a moment and say thank you for your patience. I know I said we would start at 10 a.m. this morning, but one of those unscheduled breaks came up between counsel and I that you could not participate in. It took us some time to work through that, so I thank you again for your patience as we resolve those issues this morning. I want to confirm with all of you before I turn over questioning to the defense. As each and every one of you sit here today, are you an Orange County resident? Raise your paddles if that does not apply to you. Okay. Juror number 45. Yes, sir.
I recently moved to Seminole County, but I haven't
When did you move to Seminole County?
My lease began August 1st.
Okay, but are you still a registered voter here in Orange County?
Yes.
Okay. Can the parties approach for a moment? Members of the jury, again, thank you for your patience. We're going to take a short break at this time. Don't go far, 5 minutes, just outside. And if jurors in seats 39 and 45 could stay behind. The rest of you, same instruction I've given you the last couple of days. There's still no case. Do not discuss this case. Don't do any independent research or investigation. And don't talk to yourselves about the case. You can talk about anything else other than those things. And thank you. Y'all can be seated. You're good. Thank you, sir. Appreciate you. All right. Jurors in seats 39 and 45, thank you so much. In speaking with counsel for both state and defense, we're going to go ahead and discharge you from your jury service at this time. Please report back to the first floor, jury services. They'll validate your parking and give you any additional instructions. And again, I thank you for your time and your sacrifice during this week. Enjoy the rest of your week. And thank you again. As addressed at sidebar, jurors in seat 45 wearing badge 240 has been stricken for cause by way of stipulation, and juror in seat 39 wearing badge 551 have been stricken for cause by stipulation. One other additional matter, juror in seat 51 had advised either yesterday that did you recognize anyone? She had advised that there was a law student that she recognized she had seen at some volunteer organization. She's in fact Judge Leach's intern sitting in the box. And ma'am, if you please could introduce yourself for the record.
Yes, we're just with her today.
Okay. So she is not a member of our panel. So I just wanted to put that on the record as to who it is that she may have noticed, and that person is not a member of our panel. All right, we'll be in a short recess until our panel comes up.
At some point, you were going to talk to Ms. Boone about the lawyers, some being out at the time?
Yes. Okay. Ms. Boone, one of the matters that we addressed at sidebar out of everyone hearing is that I've noticed that one of your lawyers has been in and out of the room and sometimes been waiting, or this morning I asked you if you were prepared without your attorney being present. You said yes. Your lawyers have advised me that due to scheduling and speaking with other witnesses as to coordination, not all of your lawyers may be here all at the same time. It may be Mr. Owens, maybe Mr. Henderson. It may be a combination or less than that much. So the question I have for you, ma'am, are you on board with proceeding without your full defense team being present at all times?
I am.
Okay. Any further inquiry state as to that issue?
No, Your Honor.
Any further inquiries to that issue, Mr. Owens?
No, sir.
Okay, thank you all very much. We'll give the juror another 2-3 minutes, and then we can have the deputy bring them back in. Thank you. Sorry. Try again, sir.
Can you hear me?
Yes.
That works?
Yes.
Okay, well, good. Thank you.
Good? Okay.
Unsolicited advice?
Yes.
The tie, I think, works better because when it's on your lapel, it's very directional when you turn your head. That's all.
Oh, really? Okay. It's that close, you know. You can hear me pretty. I'll do it like HGN and move my whole body. So, keep my head still. Oh, fuck, nah. Thank you. This is the third one.
So 3, State of Florida versus Sarah Boone. State.
Steve Ketchum on behalf of the state.
William J. for the state.
Defense.
James Owens for Sarah Boone.
Tony Henderson for Sarah Boone.
Kevin Beck on behalf of Sarah Boone.
All right. Ms. Boone still seated at counsel's table. We're bringing our jury back in. Let's all stand, and we'll turn over the questioning to you, Mr. Henderson. State, do you recognize our panel? Defense, do you recognize our panel?
Yes, Your Honor.
All right, members of the jury, again, if you could please, you can be seated, thank you. If you just raise your paddles to confirm that you complied with the court's instructions during this last break. Record reflect all paddles have been raised. With that, Mr. Henderson, you may proceed, sir.
Yes. May it please the court, counsel. Ladies and gentlemen, good afternoon. That was my first challenge in public speaking. I've been practicing all day that it's good afternoon because we're here in the afternoon. I'm used to saying good morning. So even I have challenges when it comes to public speaking. I want to thank you for being here. Again, my name's Tony Henderson, and it's my pleasure to represent Sarah Boone. And I know the judge has told you, but on behalf of our defense team, in regards to Ms. Boone, we would like to thank you. And I'm going to tell you why. America is still great. And the reason that America is great is because of systems like this that we have. It's our Constitution. Because in this country, our citizens are protected. In this country, we have limited government. In this country, based on our Constitution, and the Sixth Amendment right that we have in our Constitution is the right to a jury trial. Folks, in some countries, they don't have that. In some countries, you don't have a jury. In some countries, they have professional jurors. In some countries, only a judge decides. In some places, you have to prove yourself innocent. We don't have to do that here. This is the way I rank these things. And of course, I have my bias as far as what you can do, the service that you can do for your country. I have this ranking. And I have a bias when it comes to this ranking, and I'll tell you about it. But number one, I think, by far, is military service to your country. Number two, I believe, is jury duty. And my bias for the military service is the fact that my dad spent 22 years in the Navy.
I'm going to object. No pending question.
Overruled for now.
Thank you. Number two is jury duty. Quite frankly, it's probably something I'll never be able to do because of the position that I'm in, but I would love to do it. Truly, folks, it's you that make this system work. All right? And number three, I think everybody should vote. Okay? Now, I want to talk to you about the trial process, and this is voir dire. And voir dire means to speak the truth. This is my only opportunity that I will have to talk to you. Okay? Because once these proceedings start, it is against the rules of conduct for us to have any communication with you on either side, being on the state side, being on the defense side. So if you were to run into us or see us somewhere and we don't look at you or we don't acknowledge you, we're not being rude. Okay? We're just following the rule. And it gets ingrained in us because this afternoon, when I came up the elevator, it was a couple of people with jury badges on. I made sure I didn't say anything. Okay? But that's the reason. But for a trial, I break it down to it being 4 fundamental rights. And these 4 fundamental rights apply to everyone. They would apply to me if I was on trial. They would apply to you if you were on trial. They would apply if you had a loved one or a friend on trial. Today and for the rest of this trial, they apply to Miss Sarah Boone. And the first one of these fundamental rights you've already heard about. But sometimes people say things differently. And the first one is the presumption of innocence. We've all heard that term, correct? Raise your paddles if you've heard that term. You probably heard it enough yesterday. But prior to yesterday, I'm sure you've heard that term before. Is that correct? Could you raise your paddles if that's correct? And all of you have said that you can presume Miss Boone to be innocent. Okay? That means at some point in time, and the judge is going to read you an instruction, and I believe the judge already did yesterday, that presumption of innocence means that you believe that she is innocent. About the presumption of innocence and how we are, can we all set aside and presume Sarah Boone to be innocent? Thank you very much. The second one of these I want to talk about proof. Okay? You heard about that yesterday. The judge told you in any criminal case, it's burden of proof. It does not have to prove anything. Okay? Well, jury number 6. Sir, do you know why the state has the burden of proof? Why should it be? Do you think it should be that way? That the state?
If they're prosecuting her, yeah.
Why?
That's the law.
Okay. Can anyone else give me a different reason? By show of paddles that element A. As to element B, there was. But as to element C, you have a reasonable doubt. Okay, and I used to try to say, Granny, it don't work like that. But that was her fundamental belief. Okay? Is there anybody who feels fundamentally like my grandmother? Anyone? And it's something that I forgot to tell you when I went into this for dying, talking about it's to speak the truth. And why this is so important at this point in time, folks, because guess what? I can't read what's in your mind. Okay? I can't. But more importantly to me, I don't know what's in your heart. I don't. So you have to tell me. And if it's something I say that confuses you or you don't understand, raise that paddle and I'll try to clarify it. Okay? All right. So, do you know what that means? Because the judge is going to give you an instruction about if Ms. Boone elects not to take the stand. And that instruction is going to include that you cannot consider that in any way in your deliberations. Do we understand that? Okay, great. So guess what, folks? You're back there. And you're talking, and it's close. And someone says, well, we didn't hear from Ms. Boone. Nope. That's wrong. Do you understand? Because you cannot consider it in any way. Do we understand that? Yes. Okay. Can we all adhere to that? Okay. Anyone with a problem with that? Okay. Thank you. So none of my grandmothers out there. All right. All right. I'm going to get to some more case-related questions, as I call them. I just want to make sure, is there anyone here who knows someone with the state attorney's office anyway? Is there anyone here who knows someone from the state attorney's office? Anybody who works at the state attorney's office? Show of paddles if you do. No one? All right, good. Thank you. All right, there was a question asked yesterday about interactions with law enforcement or who knew people or related to or had friends with law enforcement. I remembered we took them down. I want a follow-up to that question that I just want to ask you, okay? Is it anyone who has such a close relationship with law enforcement that it would be hard for them if they're on this jury and after they listened to the evidence and said to themselves, the state did not prove this case. And we had to find her not guilty because we followed the law. Is it anyone in a relationship would have a problem telling that person that's what we had to do and that's what we did? Anyone in that type of relationship? Okay. Thank you. Now, in the state of Florida, there are certain things that we have that are known as affirmative defenses. Okay? One of these things that we know as an affirmative defense is the justified use of non-deadly force and also the justified use of deadly force. Okay? AKA, meaning also known as self-defense. All right? I think everyone's nodding now because they recognize that term, self-defense. By the show of panels, how many people recognize the term self-defense? Is it anyone here who disagrees with the principle that a person has the right to defend themselves? Show of panels. Anyone? Okay. Is it anyone who disagrees with the thought that a person has the right to defend others? Anyone fundamentally disagree with that? Basically, what I'm asking is anyone who thinks that slap my cheek and let me turn the other one to you so you can slap it? Anyone? Okay. Has it been anyone in this panel who's ever been put in a situation where they had to defend themselves? Just show of paddles, please. Yes. 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 Anywhere. Those are all good questions. Anywhere that you've been in a position, it could have been at school and someone's come up and started picking on you or hitting you or whatever. Do you understand? Okay.
It's just physically defending yourself, though, not, saying, I didn't say that.
Yes, we're talking about physically defending yourself. School, middle school, it could have happened. It could have happened when you were in diapers. Okay? Yeah. So, at any time in your life, have you felt or did you have to defend yourself? Can we show paddles, please? Okay. Could you hold them up? And we'll start because my arm would get tired. It was getting tired yesterday. You can. This is my left side, so on the right side, correct? Okay. Yes, just on this paddle, and that's paddle number 1, paddle number 2, paddle number 4, paddle number 5, paddle number 6, paddle number 7, paddle number 15, paddle number 17, 18, paddle 32, paddle 41, paddle 43, paddle 44. Then we're going to be in paddle 47. I'm sorry, sir. Were you holding it down low? I just missed you. Yeah. Okay. Thank you. Now, this side. Paddle number 14. Paddle number 24. Paddle number 26, 27. Paddle number 36, 38, 48, 49, 50, 51, 53. Okay. Would you all agree with me that each of those situations would have been different? Anyone who disagrees with that? Okay. So would you agree with me that each of those different situations, if you disagree, just raise your paddle, that each of one of those situations would have to be determined on their own merit and their own facts? Would you agree with that? Okay. Is there anyone who disagrees with this? A person has the right to defend themselves, even if it means using a weapon.
Objection from statement of the law.
Approach.
The objection is sustained. Mr. Henderson, you may continue.
All right, as I told you before, there's two types of self-defense, okay? Self-defense with non-deadly force, all right, we're not going to be talking about that in this line of questions, all right? And the line of questions that I'm talking about is that self-defense with what's known as deadly force, okay? That's basically force that is likely to cause death or great bodily harm. All right? Do you understand me there? Okay? In that situation, you have to be in fear of that time. The person has to be in fear of that time that is going to be an action against them or a threat or an imminent threat against them of being harmed with great bodily harm or death. Or a forcible felony is being attempted on them. Do we understand that? Examples of forcible felonies are aggravated assault, aggravated battery, felony battery. Some examples. Okay? In that type of situation, is it anyone who believes that a person should not be able to use a weapon in defending themselves? Is it confusing?
Depends on the situation.
Can we get a
Yep.
paddle number?
Yes, please. I will. Paddle number 24.
It depends on the situation. I mean, they can negotiate and walk away. And if the wall, then do what they can, but always trying to walk away as peacefully as they can.
Okay. Now let me ask you a couple other questions, sir, during number 24. Yes. Thank you. During number 24, when the court reads you the law on justifiable use of deadly force, will you be able to follow that instruction?
Yes.
Okay. Now, would you agree with me that every situation is different?
Yes.
Is that correct? Okay. Let me give you an example. If someone was to put a gun in your face,
Right.
okay, do you think that you have to wait for them to fire it?
No.
Before you fired your gun?
No. Self-defense first.
Is it anyone who thinks that you should have to wait? Anybody? Okay. So in certain situations, based on the facts, are you saying there would be times when you feel it would be appropriate to have to use a weapon? Or I don't want to put words in your mouth. You tell me. Oops.
Well, if your life is in danger, you do what you can. It depends on the moment that you're in, but even though you try to look for peaceable solutions, but if your life is in, if your back is up against a wall, there's a knife at your throat, you do what you can. Not the intent to kill, but to resolve the situation without being killed, if you understand that part, yeah.
Okay. Would you judge it by each situation, sir?
Yes, every situation is different.
Let me ask you this. Would you consider physical ability when it comes to it?
Can be physical, and it can also be negotiating verbally. Sometimes that works. Depends on what the attacker's motive is at that time. So, you know.
Well, let me give you this example, and then you tell me about that. What if it's a male, 6'5", 200 and something pounds, and a female, 5'2", 105?
Objection?
Approach.
The objection is sustained. Mr. Henderson, you may continue.
Yes. Sir, I need to change that. Male, 6'5", 200 and something pounds. Okay? Female, 5'9", 120 pounds. Okay? Would you consider that when it comes time to how a person would have to defend themselves?
Yes. If it's life and death, it's either their life or your life. So yes, it would be, if that's the last resort and there's no other recourse, I would say yes in that situation, because it's either their life or your life.
Okay. Yeah. All right. Let me ask you this, and looking at it like when you say it like that, but would you be able to recognize the difference in probably the physical abilities of a man who's 6'5" and 200 and something pounds versus a woman who's 5'9" and 120 pounds?
Well, are you talking about the lady defending herself against the guy that's...
Yes, sir.
Well, in that case, it's survival, I mean, she can either run away or depends on... But, I mean, my point is you try to avoid deadly force if at all necessary. I mean, that's the last resort, but if you can, you don't use it, but if that means your life, then of course, in that case.
Okay. Thank you, sir.
Yes.
Juror number 5. What's your opinion on that?
As a woman, I would want to defend myself. It doesn't matter how big of a guy. I'm going to try to defend myself until he either hurts me or I take him out and get away.
Okay. Do we have juror number 10 here? No. You got me. I should have had my seat chart. 10. Juror number 17.
If you have a larger, more imposing person, it's a physical altercation with a smaller person. That smaller person is going to have to consider themselves and others.
Can we get the mic over there, please? Sir, yes, could you repeat that, please? Juror number 17.
Thank you. Does that work?
Yes.
What I was saying is if there's a larger, more imposing physical presence there that you're fighting against, that could put you in a situation where you have no choice but to use whatever's available to you, because in the example you gave, you're not going to win that fight 99 out of 100 times.
Okay. Thank you, sir. Is there anyone who disagrees with what juror number 17 just said? Hold your panel up if you disagree. Is there anyone here who, are you holding it up that you disagree, sir?
Only slightly. I just only disagree with what he did. I think it's more likely than 99.
Okay, thank you. Anyone else who disagrees? All right. How many people show a paddles who agree? To what he said. Who agrees? Okay. Thank you. Do you all understand, in the state of Florida, when it comes to defending yourself, either with non-deadly force or deadly force, that you don't have to wait for the commission of the act. Do we understand that? Am I confusing anyone? Okay. Meaning that if someone holds their hand up and fist up and make like they're going to hit you, do you understand that to use non-deadly force in that scenario, you don't have to wait for them to hit you? Do we understand that? Okay. Also, in the use of deadly force, if someone holds up a gun, all right, you don't have to wait for them to fire it. Do we understand that? Yes. Is there anyone who disagrees with that? Also, in the state of Florida, if it's two people or someone has knowledge of a person or the other person who's exerting force on them, if they have had difficulties or events in the past, that could be considered in their use of either non-deadly force or deadly force. Do we understand that? All right, if you understand that, show of paddles, please. Okay.
I don't understand what you said.
All right. Let me try to give you an example. A and B are school kids, okay? They go to school every day. Let's say they're in middle school, all right? And for the past couple of weeks, you know, A has been beating on B, okay? So, A and B go to school again one day. Next thing you know, A comes up to B. And B just automatically hits A.
Approach. Objection is sustained. Mr. Henderson, you may proceed.
Let me try to explain it to you like this, ma'am. If you hear an instruction that you can consider past difficulties between the parties if in determining if someone was justified in using non-deadly force and deadly force or deadly force, could you follow that instruction? Yes. Okay. Is there anyone here who could not follow that instruction? Yes, ma'am.
I need a microphone.
Oh, okay.
We get juror number 13 a mic.
I'm not doing a good job with the mic. I'm sorry. I'll get better.
So, like in your example, if I'm allowed to use the example that you were just using on A and B? No.
Not the example that I used before. Okay. That was found to be wrong.
Okay. So, I guess my question is, even though there's been past events that have happened and they could weigh in with that, something still has to be happening in that moment for them to defend themselves in that way, right? It's not like somebody walks up to you and you can just defend yourself.
You're absolutely correct, man. Because what the statute is going to say and what the instruction is going to say, that has to be an imminent threat, okay? An imminent doesn't mean that you have to wait for it to happen, but you have to have reasons to believe that it's going to happen, okay? But the instruction that I'm talking about, do you understand that past difficulties can be considered? Because that's what the jury instruction says. Can we follow that instruction? Yes. Is that correct? Can you follow that instruction, ma'am?
Yes, sir.
Okay, thank you very much. How many people here own guns? Or at least one gun? Okay. All right. Let's start on this side over here. Juror number 4. I'm not going to ask you how many you own. That's your constitutional right. I'm not going to. I asked that one time. Somebody said, "I'm not telling you how many I own." So I learned from that. What's the purpose of your gun?
My American right.
Yes.
Self-defense, and then they're just fun to shoot.
Okay.
Recreation.
All right. Thank you. Juror number 5.
So they're actually my husband's, and he had purchased one for me for that reason. If he was home or not home with, and I was by myself with my child, someone were to break in, we would have us self-defense.
Okay. Thank you. Who else on the first row on this side owns a gun? Anybody else? Second row? Yes, sir. Juror number 15. Excuse me? You have to speak up, juror number 15. Oh, there we go.
It's basically for home defense. That's all.
Home defense? Okay. Thank you. Anyone else on the second row on this side? Juror number 17.
Exactly what she said. Exercising my right, self-defense, and I like to target shoot.
Okay. Thank you. Anyone else on this row? Yes, sir. Juror number 19.
Self-defense.
Self-defense.
I don't really shoot, but I have it in case I need it.
Okay. Thank you. Anyone else on this row? Third row on this side. Anyone owns a gun? Okay. Last row on this side. Anyone? Let's start with juror number 44 because she has the mic, I believe.
Same reason as the lady up front.
Okay. Thank you. Juror number, what's your panel number, ma'am? 43. Thank you.
For self-protection, I live alone, and also in my job I have drugs, and so I'm a veterinarian, so if anyone knew that and people are crazy, then they might want to break into my house and try to or into my truck and get drugs.
Or in other words, if anyone gets froggy.
I'm sorry?
I said froggy. It's a slang term. I'm sorry.
Yeah, so just, it makes me feel safe.
Okay, thank you. And sir?
Yeah, just old hunting shotguns.
Okay.
Hunting rifle from my father and grandfather.
All right, thank you. Anyone else on this side own a gun? This side, if we can have the mic come this way, would be great. Oh, they have a mic on this side too? That's great. It's like a relay team. All right. Juror number 23.
For self-defense.
Self-defense. I like your juror number, sir. That was my football number.
Home defense, and recreation.
And recreation. Thank you, sir. That was juror number 24. This is juror number 26.
Home and self-defense and shooting practice.
Okay, thank you. Anyone else? Oh, did I get the first row here? I didn't get the first. Yeah, juror number 8.
Sport and recreation.
Sport and recreation. Okay. Were you able to hear that? Okay. All right. Now, I'm on the third. Anyone else on the second row on this side? On the third row on this side. Anyone gun owner? Juror number 37.
Just for recreation and home defense.
Okay. Anyone else on this side? On this row, I'm sorry. Back to juror number 51. Thank you, ma'am.
I don't own a gun, but my husband bought one for target shooting. I don't even know where it is, so he's got it locked up somewhere.
Okay.
But it's not for home defense, though.
Okay. Well, thank you, ma'am.
Is that it?
Recreation, home defense, and our rights.
Your number, please, your panel number? 49? Okay. Thank you, sir. Anybody else? Anyone I miss as to gun ownership? All right. Thank you. Folks, if you disagree with this, raise your panel for me. Yeah, I'm sorry, I'm about to say it. If you disagree with this, raise your panel, okay? Your home is a sacred place. Yes. Anyone disagree with it? Your sacred place. Your home is a sacred place. Okay? All right, let's do it this way. I'm sorry, yes. I did it the wrong way. Let's do it this way. If you agree with this statement, raise your panel, please. Your home is a sacred place. Okay. Is there anyone here who believes that you can't defend yourself in your home? Okay. If you do, raise your panel. All right. Thank you. All right. It's going to be one other thing that I'm going to talk about with this justifiable use of non-deadly force or justifiable use of deadly force. Okay? And it ties in with the burden of proof because remember, it's the state, the government, who has the burden of proof. All right? However, folks, once the judge reads you an instruction saying that it's an affirmative defense of justifiable use of deadly force or justifiable use of non-deadly force, do you understand that Miss Boone does not have to prove to you that she was acting in justifiable use of non-deadly force or justifiable use of deadly force? Do you understand that? Yes. Guess what has to happen? Juror number 3. I hadn't picked on you. What has to happen, sir? Do you know what has to happen? What do they have to prove? Yeah, you're really close, but this one's tricky. You're really close. You're almost at that. But you know what? The state has to prove to you that she was not acting in self-defense. Either deadly force or non-deadly force. Do we understand that? Okay, because it gets a little tricky when you think about it. So she doesn't have to prove that she was. Once the instruction is given, she doesn't have to prove that she was. They have to prove that she wasn't. Do we understand that? Can we all follow that? Is there anyone who thinks it should be a different way? Okay. Is it anyone here, and I think a little bit of this man came up yesterday, that has ever been in a situation that either they were abused or part of an abusive relationship, or they know someone who was abused and part of an abusive relationship? Show of panels, please. Okay. And if I remember correctly, didn't we cover this yesterday and these things? All right. So I just have a couple additional things that I want to talk about when it comes to this. Folks, is there anyone who disagrees with this? That sometimes people are just embarrassed and don't want to talk about those situations. If you disagree with that, raise your panel, please. Do we understand that? Okay. Would you agree with this, that sometimes the person being abused tries to minimize the situation? Is there anyone who disagrees with that? Is there anyone here who either themselves, yourself, or knows someone who has stayed in an abusive relationship over an amount of time? Raise your panel. Okay. Is it anyone here who has ever tried to talk someone into leaving an abusive relationship? Raise your panel. Okay. Thank you. All right, we're going to start over here. Juror number 2. Without telling me who it was or what the situation was, did they follow your advice?
Yes, in the end.
In the end? Did it take a while?
Yes.
About how long did it take?
There were a couple of different instances. So one of them took about a year, and then another learned about it as they were getting out of it. But that took, they had been in the relationship for a number of years before I even met them. But they ended up leaving after about a year and a half to 2 years. I don't remember.
Okay. Anyone else on this front row who had to paddle up? All right. Second row on this side. Anyone? Yes, ma'am. Did the person listen to you? The microphone's right behind you, too. I'm sorry.
No, they did not.
How long did you try?
Well, over a year.
Okay. Thank you, ma'am. Anyone else on this row? This second row? On this side? Ma'am, 21, can we pass the mic down, please?
I too found out late in the game, but when I did, it did take a little while, a couple months.
Okay. Thank you. All right. Anyone on the third row? All right. Thank you.
She left the person after about 10 or 11 years, but it was not because of anything I said. And I did talk with her the entire relationship.
Okay. Thank you. Anyone else on this third row? Fourth row? Yes, ma'am. Juror number 43.
One girl, I tried to help her, so I let her stay with me, and I brought her here to do a restraining order, but then it all fell apart. And then she was a mess, so I got her out of my life, but I don't think that it would have made any difference.
Okay.
And then I also know quite a few clients, not very well, but you see it happen over and over, and people usually don't leave.
Thank you, ma'am. Is it anyone else on this row? Okay, let's go to this side. Anyone on this side? Juror number 8. Where's our mic here? Here it comes. Yes, sir.
No, they did not leave the relationship.
Okay. How long did you try to talk to them?
Years.
Okay. Thank you. Anyone else on this row? Yes, ma'am. Your number, please. 13. Got it.
Same years, and I think in most cases that I've seen, like it just has to be them that finally makes the decision. It doesn't really matter what you say.
Okay. Anyone else on this front row? All right, second row. Anybody? Juror number 28.
It was about 2 years. They eventually left on their own accord, but I was there in the support, offered a safe place, and they would go back and forth. It has to be their decision.
Ma'am, thank you very much. Did y'all hear that? When they said it has to be their decision. Is there anyone who disagrees with that? Basically, it has to get to the point when they say they're done. Is there anyone who disagrees with that? Okay. Thank you, ma'am. Anyone on the third row? Anyone on the last row? Yes, ma'am. Yes, sir. Where's our mic? Hey.
3 years, they didn't listen. The guy ended up leaving her. She would gladly go back to him probably today.
Okay.
That type of person.
Okay. And that was hard for you to understand, wasn't it?
No.
No?
As I grew older.
Okay. That's fair.
It was a much simpler place.
That's correct. Well, simpler in some ways, harder than others. Anyone else on this row? Yes. Juror 50.
My cousin is off and on in the relationship. The family knows. We've tried to talk to him. It's ongoing.
Okay. Anyone else? Yes, ma'am.
A colleague, and I talked to him for maybe a month, but they did it on their own years later.
Years later? Thank you. Is there anyone here in the panel who's ever had an injunction filed against them for no contact, that you couldn't have contact with a person? Anyone here? Okay. Excuse me? Somebody else, but it wasn't against you. Is that right, ma'am? Okay. Thank you very much. Yes, sir. Okay. All right. And that was your wife, correct? Not yourself. Okay. Thank you, sir. Thank you for your candor. All right. Anyone else? Thank you. And that was jury number. What's your pallet number, sir? 15 and ma'am, 13. I got it. This term came up yesterday, battered spouse syndrome. There were some people who said that they were familiar with the terminology, okay? So I know that, and we have that information, okay? But this is something that I want to talk about. Is there anyone here who knows someone, friend, relative, who just knows everything about anything, if that makes sense? Anybody show a panel? Do you know someone like that? Okay. All right, so there's very few people who know someone like that. Well, we all agree that there are just things in life that we don't know about. Right? Anyone disagrees with that? Panel. Okay? Guess what? When my car breaks down, I'm going to the mechanic because I don't know a thing about a car. Okay? Now, when my AC or air conditioner goes out in the summer, I'm calling the guy as quick as I can because I know nothing about the AC. Do you understand that? Okay. So, when the car guy says, oh, Mr. Henderson, it's going to cost you about $2,000. You know, what do I want to do? Or what does a reasonable person? Well, what's wrong with it? Okay? But guess what? It gets to a point I have to rely on the car guy because I don't know about it. Do you follow me there? If I get sick or if anyone gets sick, where do you go? Do we have any doctors out here? Okay. Thank you, ma'am. And did you say that's the vet clinic? Do you?
Yeah, I'm a veterinarian.
You're a veterinarian? Yeah, I have a German Shepherd.
Except the patients don't talk to you, so.
Yeah. Yeah, I let him stay with some people who had dogs, and he don't even miss me. I've been here in Orlando all this time. But, so, what do you go to the doctor for? Yeah. Aren't you trying to find out what's wrong? Okay. Folks, there are some people under the law who become expert or known as expert witnesses. Guess what? Because they know about a topic more than we know about a topic. Do you agree with me there? Is it anyone who disagrees with me on that? Raise your paddle if you disagree. Can you all, by show of paddles, listen to an expert testimony and weigh it accordingly? Can you do that by show of paddles? Everybody can do that. Is that right? And guess what? You're not going to hear me say anything else about an expert because I really don't know about the expertise. That's why we have the expert. The expert can talk about it. Okay? We agree with that? Everyone agree? Okay, thank you. All right. There's been talk about fear and fears and what kind of fears people can have. Okay? If you disagree with this, just raise your paddle. Oh, no, let's do this. If you agree with this, raise your paddle. Okay? That some people can have the fear of not being wanted. Do you agree with that? Okay. Thank you. Anyone disagree with that? Okay. Some people can have the fear. Oops, excuse me. Yes. Thank you. Number 6. I'm not even going to ask you to explain it because I understand some things we just don't agree with. Okay. All right. Thank you, sir. All right. Some people can have the fear of not being good enough. Would you agree with that? Okay. Is it anyone who disagrees with that? Number 6. Okay. Thank you. Paddle number 6. Thank you. All right. Some people can have the fear of being hurt emotionally or physically or both. I said that all backwards, though, but you know what I mean? I should have said emotionally, physically, or both. Okay? Anyone disagree with that? Okay. Number 6? Good? Okay. Is it anyone in the panel by show of your paddles that's claustrophobic? Okay. Can we keep that up? We'll start on this side first. Juror number 3. Thank you. Juror number 34. Thank you. Juror number 44. Thank you. 44. Did you get it, Miss Andrews? Okay. Yep. You can put your paddle down there. Juror number, this side. Paddles up, please. Juror number 9. All right. Juror number 40. Juror number 51. Juror number 53. Okay. All right. Thank you. Is it anyone here, maybe I asked this another thing, but let me make sure, who has a medical background? I don't mean a doctor, but just has a medical background. Okay. Let's do this. Could you hold we're going to start on this side over here. Could you hold your paddles up high, please? All right. So we're going to go juror number 5, juror number 16, juror number 18, juror number 21, juror number 31, juror number 43. Thank you. Anyone else on this side? All right. On the right side, juror number 51. Anyone else on this side? Thank you very much. All right. I have to talk about another topic here. Alcohol. It was brought up yesterday. Okay? So this is what I need to ask you. If anyone disagrees with this, just Raise your paddle if you disagree. That alcohol affects people differently. Anyone who disagrees with that? Well, let's do it with agree. It makes it easier. I'm sorry, I get confused. I'm confusing people. Let's do it with this. Anyone agree? Who agrees with this statement that alcohol affects people differently? Do you agree? All right. Anyone who disagrees with that statement? Okay. Now, would you agree with this? Who agrees with this? That sometimes people or certain people drink alcohol and they get happy and giddy. If you agree with that, raise your paddle. Okay. Sometimes people drink alcohol and just get downright mean. Do you agree with that? Raise your paddle. Okay. Anyone who disagrees with that? All right. Folks, sometimes there's people who don't drink a lick of alcohol and are just happy and giddy. Would you agree with that? Okay. Anyone who disagrees with that? Folks, sometimes there are people who don't have a drop of alcohol and they're just downright mean. Do you agree with that? All right. Thank you. Now, I think yesterday it was juror number 4. Juror number 4, correct? You drank, is that correct? And we talked about drinking yesterday, is that correct? Okay, let me ask you a couple questions about drinking. Have you ever drank and did something that you would not normally do when you're not drinking? Okay. All right. Have you ever drank and said something that you didn't mean or regretted the next day that you said it? You agree? Has that happened? If you even remember saying it. Correct? Has it ever been a time where someone had to remind you the next day or a couple of days later, you said something rude to me when you were drinking? Has that ever happened? Said things that you wouldn't normally say? Okay. They could be nice things. Yeah. Right. All right. So, is there anyone who disagrees with those things? Do we all agree? Here's the thing. Do we all agree that people can do things after they've been drinking that they wouldn't normally do if they were sober? Does everyone agree?
Approach. Objections overruled. You may continue, sir.
Thank you. Is there anyone who disagrees that people act differently when they drink? Okay. Now, juror number 26. Yes, sir. Do you drink? Okay. Do you drink at home? Do you drink out socially? Okay. Are your drinking habits any different at home than they are out socially?
Probably a little bit more socially.
Okay. You probably drink more socially, meaning more occasions, or what?
Quantity.
Quantity? Okay. Good. Is there anyone here who drinks more at home than they do out socially? Okay. Thank you. Juror number 38. You drink more at home than you do out socially? Why?
Because I can stumble to my bedroom more than I can stumble to the car.
Hey, man, that's A+. That's exactly it. That's exactly it. Is there anyone here who disagrees with that? Okay. Juror number 49. Sir, first of all, I'd like to say congratulations to you, okay, and continued success, all right? And I actually appreciated the story that you shared with us. I have a couple questions, though, okay? How long have you been a non-drinker?
Well, since 1987.
Since 1987? Okay. And prior to being a non-drinker, how long did you drink? How many years did you drink?
Probably 15, 18 years.
15, 18 years? If you don't mind this sharing this with you, when did it come to you that you thought or recognized that you had a problem with drinking?
Well, I was going through some difficulties with a wife that I had at that time. I was overseas. The last thing I remember doing was drinking 2 beers, and I evidently blacked out, and I embarrassed myself in the Air Force.
Okay. Sir, was there ever a time in your life that someone confronted you about drinking and you denied that you had a problem?
Actually, multiple ways, multiple directions. I had people telling me that I didn't have a problem, and I had people telling me that I had a problem.
Okay. Was it your drinking buddies who were telling you that you didn't have a problem?
Not only my drinking buddies.
Not
I
only
had
you.
commanders telling me that I didn't have a problem.
Okay. Were there loved ones telling you that you did have a problem?
No, actually, when I confronted them, telling them they had to stop doing that, they actually got a little upset.
Okay. Who was it who was telling you that you had a problem?
Medical personnel.
Okay. Did you listen to them?
Initially, no.
Okay. Sir, can you tell us what changed your mind or your attitude?
To be honest, after numerous incidents, I know my family history. I felt it either I needed to stop drinking or just take myself out into a field and eliminate the problem before I actually hurt somebody else.
Okay. So you looked in the mirror?
Absolutely.
Is it anyone here who disagrees with the fact that there are people who are in denial about a drinking problem? Anyone who disagrees with that? All right, let me ask it in it this way. Would you all agree that some people are in denial that they have a drinking problem? Okay. Thank you. All right. This is what I need to ask you now as the panel, and I want you to understand. Because we've talked about how people act differently when they drink, or they'll say things differently, or they'll do things differently when they drink. Do we all understand that being drunk is not an excuse for your actions? Do we all understand that? Yes. Okay. Raise your paddle if you agree with that. That being drunk is not an excuse for your actions. Do we understand that? Okay. Do we understand that in the state of Florida, there is no defense for voluntary intoxication? Do we understand that? So you can't come in the state of Florida and say, well, I did it because I was drunk. Do we understand that? Okay. Is it anyone here that would not hold someone accountable for their actions merely because they were intoxicated or drunk? Anyone here? Anybody going to do that? Okay. All right. Thank you. You ever heard, has everyone here heard the term, by show of paddles, rush to judgment? A rush to judgment. Okay? Is there anyone here who has a story that they can share about them rushing to a judgment and it turned out that they were wrong? Anybody? All right, I have one. Tell me if you can agree with this. In a building one day, come out from the building, I'd done my shopping and stuff. I go out to the parking lot, and I'm walking up to my car. And as I get closer to the car, I see that there is a dent, a big dent, in the back driver's side of my car on the bumper. So guess what? I'm mad now because it wasn't there when I left. So I'm going up to it and I see, man, someone hit my car. So I'm looking for a note and I don't see a note to see if the person who left a note or information. So then I get to the point where now let me put this in here. Let me go and see if they have any video footage inside so I can see who hit my car. Okay? So on the thing of putting it in there, I clicked my key fob and the door wouldn't unlock. Now I'm really mad because they done damaged everything. Can't even get in my car. I go to the handle and I push with my thumb the button to get in. And I can't get in. I said, oh man, this is just bad. So I walked back to the back of the car and I happened to look. And I said, that's not my Florida State University license plate. Matter of fact, that's not my car. At the time, I was driving a black Nissan Maxima. At this time, this car was a black Nissan Altima without a Florida State license plate. Would you agree with me, folks, that sometimes everything that needs to be investigated? Is there anyone who disagrees with that? Okay. Would you all agree that there should be a full investigation before a decision is made? Would you all agree with that? Anybody, by show of paddles, who would disagree with that? By show of paddles, who agrees with that? Okay. You know, when I found my card too, which was behind me over there, I was relieved. But then, you know, I thought maybe that car was like that beforehand. All right. Now I have to talk about one of my, well, it's one other thing I have to talk about. Remember yesterday there was conversations about you being the, as the jury, you sit in the position of determining what the actual facts of the case are, okay, what the actual evidence of the case are, and you have the great power of giving evidence its weight. Some you can consider greatly, some you could give less weight to, or some you have the power just to ignore it all, and you don't even think it's important. Do we understand that? That's your power as jurors. So it's talking about, one of the things we're talking about, one of the things too, you're going to have to determine credibility of witnesses. Okay? Credibility of witnesses. And they talked about some things, and the state talked about some things. Would you like to look at them? Would you just be able to hear them? Or could you be comfortable with that? All right? The judge will read an instruction when it comes time, and I want to know if everybody can follow this instruction. It's going to be weighing the evidence, and the judge is going to give you a series of things that you can use in determining which evidence is the best evidence, which evidence isn't so good, or which evidence you don't find credible at all. Do we understand that? Okay? But I want to focus on one of those. I'm telling you it's more, but this is the one I'm focusing on. Weighing the evidence. Does the witness testimony agree with the other testimony and the other evidence in the case? Do we understand that? Okay. Does the witness testimony agree with the other evidence, the other testimony, or other evidence in the case? Can we do that? Is it anyone who feels that they're not capable of doing that? All right? Now, when we say other evidence, we're just not talking about other testimonial evidence, because evidence comes in different forms. Okay? There could be physical evidence. Do we understand that? There could be scientific evidence. Do we understand that? Or there could be expert opinion. Do we understand that? Can you weigh all those things, follow the law, and make a fair and impartial decision based on the law? Correct? And based on what else? That high standard of proof, the highest that we have in our country, beyond and to the exclusion of a reasonable doubt as to each and every element. Can you do that? Guess what? Two more things, I think. I'm going to check with co-counsel too. But two more things, basically. One is this. I'm going to date myself here. Or I'll just go ahead and tell you, I'm 63 years old. Okay? So, and in fact, when y'all had the opportunity to meet Lauren Henderson, okay, she's not my wife. She's my youngest daughter. We are related. Okay, so, and actually, she's an attorney now. She just finished law school and passed the bar. So that's why she's assisting in this case today. Okay, so that's the relationship. But when it comes to weighing the evidence, this is... No, I'm sorry. I'm past weighing the evidence. I was getting emotional. Anyway, This is one of the things, and she has to help me with it. That's where the age difference comes in. It's called social media. Okay? Guess what, folks? I do not have a Facebook page. Quite frankly, until it started becoming prevalent and people looking at them and stuff, I added it onto my board hour thing because they had to tell me, my staff had to tell me what the forms of social media are because I don't know them. Facebook, I guess YouTube's one too. I thought that was TV. But Twitter, Snapchat, TikTok, Instagram. Okay? So I become familiar with these things, but I'm looking for something. I'm looking for someone who lives their life on any type of social media. All right? And this is what I'm talking about. So if you're this kind of person, I want you to raise your paddle.
Did you say who lives your life not on social media?
No, who lives your life on social media. Okay? Who lives your life on social media. Well, you'll see with this example. Okay? That's it. Some of y'all are getting nervous, I can tell. You're getting nervous, but here we go. Here we go. 6 a.m., just woke up. 6:10, headed to the bathroom. 6:20, man, I really don't want to go to work today. 6:35, darn it, let me go in here and see what I can have for breakfast. 6:45, darn it, looks like either Fruit Loops or eggs. 7:05, darn it, I still don't want to go to work, but those eggs I had were really good. Okay? 7:30, I better head to work so I don't get caught in this traffic. All right. Anyone who leads their life on any form of social media or texts anyone to that extent, would you please raise your paddle? Okay. Remember that word, Vordir? To speak the truth. Now watch this. Is there anyone who knows someone that does that? I always get a yes to that part. I always get a yes to that part. So no one who knows that way. Is that correct? No one who does it. Okay. Judge, may I approach a minute, please? May we approach a minute?
Yes. You may continue, sir.
Thank you, Your Honor. All right, the procedure. When you get here, if you're on a jury, when you get here, you're going to have to turn your phone off. And you're going to have to leave your phone off, okay? I think they've been having y'all do that now. Is that correct? All right. During deliberations, you got to check the phone at the door, okay? You're not going to have it. Everyone understand that? Who's going to go through withdrawals? I need to know. Who is going to go through withdrawals? That means you're not going to be able to text someone. You're not going to be able to get on the phone and see who's trying to call you. You know what? You're not going to be able to put that last post on there. Do we understand that? Back in the day, guess what? We used to have to ask this question about cigarette smoking. Okay? I think they allow breaks for cigarettes. I don't think they allow phone breaks. Okay? So is there anyone who is that tied to their phone that they're going to be worried about that phone and not worrying about the evidence and the case and the testimony and everything else? Yes, sir.
Will there be a method for emergency?
I'll defer to the judge.
I can answer that question. So if you are selected to serve as a member of our jury, an emergency phone number will be provided that you can provide to any loved ones or friends or family. And in the event there is an emergency situation, they can call that number and we will get in touch with you.
This is a great escape.
Thank you.
All right. Judge, can I confer with counsel?
Yes, sir.
Real quick.
You are now, counselor.
I'm back on? Okay, I'm back on. There we go. You know, in our little courthouse in Santa Rosa County, you don't have to wear a mic. You know, you just, everybody's there. Oh, we got a new courthouse, but it's nothing like this.
Bless you.
Okay. Bless you, sir. All right. Great escape clause. I don't really think anyone has said today that they couldn't be fair or it's anything, but I know you've been responding to questions. This is what I want you to do. I want you to think about it. And if for some reason, it could be anything, okay, that you don't feel comfortable about sitting on this case, if you'd raise your paddle and let me know. But let me give you some examples because I don't really, before you do that, it could be the fact that you don't like the fact that I move around. You don't like the fact that I look. You don't like the fact of how I sound, okay? You don't like the fact of, darn, Mr. Henderson, what were you thinking about when you got in the mirror this morning? Okay, that don't match. It could be that. Folks, it could be as simple as this, that you think my hair is way too long. Okay? But now, or it could be something that you don't like about Mr. Owens, that you don't like about Miss Boone, that you don't like about Mrs. Henderson, and that you don't like about Mr. Beck. Miss Andrews is a little sensitive, so I won't say it, but you can consider that too. Okay? So at this time, if you feel uncomfortable, would you please raise your paddle at this time? Okay. Number 40. All right. Thank you, ma'am. Anybody else? All right. Folks, I want to thank you. I want to thank you on Miss Boone's behalf. I want to thank you on our team's behalf. People here have made us very comfortable. Sometimes it's hard going to a different place, but everybody's been very friendly. Y'all have been very attentive to me, and I really appreciate it. And I want to thank you on behalf of me, our team, and especially Sarah Boone. Thank you. Judge, that's all the inquiry I have.
Can the parties approach for a moment? Members of our jury, thank you so much again for your time, your sacrifice, and your attention. Most importantly, your honesty in answering the court's questions, the state's questions, and the defense questions over the last couple of days. We're going to excuse you for a few moments while we decide who may be able to serve as members of our jury in this case. Please do not leave this floor. There may be some of you that we need to speak to on an individual basis. And again, I'm going to give you a similar instruction that I've given you as well over the last couple of days. Please don't conduct any independent investigation or research regarding the charge, persons, places, or things that are involved. Do not have any communications with anyone else or amongst yourselves about any of those things. One last thing. You may see the state or attorneys for the state and the attorney for defense outside, maybe in the same elevator as you over the next couple of weeks. They're not allowed to talk to you, and they may look away from you. They're not allowed to communicate or have any interaction with you whatsoever. If you make eye contact, they may shy away and look away from you. I promise you, they're not doing it to be rude or insensitive. They're just trying to avoid the sense of any impropriety while we conduct this trial. With that, I thank you again for your time and your sacrifice, and we'll bring you back in as promptly as possible. Thank you.
I'd like to be able to defend some people.
All right, y'all can be seated. Thank you. We'll be off the record for a few moments for y'all to review your notes, use the facilities, take 15-minute recess. It is 3:30. We'll see you all at 3:45, and we can address any individual voir dire or charging conference at that time. Court's going to be in recess. Thank you. CF 2603, State of Florida versus Sarah Boone. State.
Yes, sure, on behalf of the state.
Bless you. Defense.
Hayes Owens for Sarah Boone. Tony Henderson for Sarah Boone.
Ms. Boone is seated at counsel's table wearing the same clothing from this morning. All right. The parties are going to continue reviewing their notes before we proceed with selection in this matter. As addressed at the bench, we will begin with jurors seated in seat 1. The state will have the opportunity to accept or reject those persons seated in odd seats. Then it will proceed to the defense for all even seats to accept or reject. Both parties have 10 preemptory challenges for the purposes of selecting our panel of 6. Once we have that panel of 6, backstrikes will be permitted. If there are no backstrikes, we will then proceed with selecting as many alternates as possible. When the parties are ready to proceed with selection, please let me know. We'll be off the record until that time. Hang on, technological difficulties here. All right, we're back on the record. Case number 2020, CF 2603, State of Florida versus Sarah Boone. Let me get appearances for the state.
Sure, on behalf of the state.
Defense.
James Owens for Miss Boone.
Kevin Beck on behalf of Sarah Boone.
All right, thank you very much. The state is advised to the juror members that they would like to follow up with 40, 49, and 51. Defense, do you have any juror members that you would like to follow up with other than 13?
Only 13.
Okay, all right. Let's go ahead and bring in juror in seat 40 wearing badge 201, and we'll stand when that juror enters. Y'all may be seated. Thank you. Ma'am, thank you so much, juror number 40, for coming back in. We've got a couple of follow-up questions to ask of you. State, you may proceed.
Okay, Jason.
State, you may proceed. Thank you.
Ma'am, I believe towards the end of Mr. Henderson's questioning, there was a question about potentially feeling uncomfortable or something to that effect.
Yes, so it was mostly because of the time. I have to be at pickup of my kids by 6. And if, like yesterday, I made it at 5:59. So if at any point we go over 5, then I would not be able to make it on time.
No follow-up. Thank you.
Any follow-up?
No.
All right. Thank you, ma'am.
Thanks.
State any position with regard to juror in seat 40 at this time. Juror in seat 40 wearing badge 201 will be stricken for cause by way of stipulation. Let's bring in juror in seat 49 wearing badge 192. Thank you. Everybody can be seated. Juror number 49, good afternoon, sir. We just had some follow-up questions to ask of you, okay? State, you may proceed.
Sir, I believe at some point during questioning there was a point in time where you indicated you'd like to speak without the other jurors present. Am I correct?
I did, but to be honest, I can't recall the purpose of everything I did.
Yeah, everything's on.
My apologies. I did say that, and I don't recall in what respect that was to, other than my comment late yesterday afternoon.
Did it have anything to do with a friend being murdered, potentially?
My brother.
Your brother, okay. And did you more details you wanted to share in private, or?
I just wanted to make sure that I wasn't omitting anything as we were discussing everything, or as you were asking the questions. It happened so long ago that I didn't really bring it up at the correct time. I just wanted to make sure that everybody knew.
Okay. Well, I understand that's a deeply painful experience that you went through and the rest of your family went through. That experience that you and your family and his loved ones and friends all went through with his loss, is that going to affect your ability to be fair and impartial in a murder trial? As opposed to, there's lots of other trials you could have done. You're going to be excused today if you don't make this one. They're not going to make you do another trial, but are you? I'm
not concerned with my ability for jury status. I do not believe that it will influence me because it was 30 odd years ago.
Thank you.
Any follow-up? No follow-up. Okay. Thank you, sir. I appreciate you. State any position as to the juror in seat 49.
No motion.
Defense?
No motion.
Okay, thank you. Let's remain standing. We'll bring in the juror in seat 51 wearing badge 325, excuse me. Y'all can be seated. Thank you. All right, juror number 51, good afternoon. We wanted to bring you in because we had some specific questions to ask of you. State, you may proceed.
Okay.
Good afternoon, ma'am. Was there a certain point in time during questioning that you indicated that you wanted to speak to us without the company of
There
Beverly?
was, and I think it had to do with it was the personality, mental stuff. Our daughter has had a lot of physical and mental health problems, has been diagnosed with multiple medical or mental illnesses. At one point, she was diagnosed with a borderline personality disorder, which I think they decided that wasn't it. So she's just had multiple diagnoses. I think that's the question that you had wanted clarified, and I think there may have been something else. If so, I can't remember.
That was my one note. And so my question is, potentially in this trial, there might be testimony about disorders that are recognized by the DSM-5-TR, which is what your daughter would be diagnosed from.
Mm-hmm.
If there's testimony about that, either by civilians or by expert witnesses, is that going to present a problem for you to sit and fairly and impartially decide that testimony and evidence that you hear and see how it applies to this case and to this defendant and this decedent?
I don't think my experience with my daughter would influence me. I think mental disorders can be complicated, though.
Okay.
So.
All right, and so just to phrase it a different way without going into the airplane ticket scenario that we use, and we use that in every trial. Do you have any doubt in your ability to be fair and impartial if you hear that sort of testimony and evidence?
No, I do not.
All right, thank you.
Okay.
Defense, any follow-up? No follow-up. All right, thank you, ma'am. Appreciate you. You just leave the microphone right in the seat next to you. Thank you. State any motion with regard to juror in seat 51.
No, Your Honor.
Defense.
No, Your Honor.
All right, let's remain standing and we'll bring in the juror in seat 13 wearing badge 2130. Y'all may be seated. Thank you. Juror number 13, good afternoon, ma'am. We just had some additional follow-up questions to ask of you. Mr. Henderson, you may proceed, sir.
Good afternoon, ma'am.
Hi.
I'll speak up. The podium.
Yeah, podium's right here, Mr. Henderson, front center.
Good afternoon, ma'am.
Hello.
Okay. I believe it was yesterday when it came up, but you said that you're going to be testifying in a case.
Yes, sir.
Is that correct?
Yes,
Could
sir.
you tell me what case that is?
It's a case, the state against my ex-husband for a domestic battery charge.
All right. Are you the alleged victim in that case?
Yes, sir.
All right. Due to the nature of this case and what you've heard in the questioning, do you think you can be fair and impartial?
I think so, yes.
Excuse me?
Yes.
Okay. Do you feel... What's your relationship with the state attorney's office now?
I don't have one.
Okay. Do you feel because they are representing you, well, not really you, they're representing the state, but you're the victim in the case, does that give you any feeling that you have allegiance with them or anything like that?
No, I would hope that this would have no impact. I would assume so.
All right. Thank you, ma'am. I don't have any further questions.
Any follow-up? Thank you, ma'am. State any motions with regard to juror in seat 13?
No, Your Honor.
Defense? No. Okay, all right. You all can be seated. Thank you. Are there any additional cause challenges on behalf of the state? Yes, sir.
May I remain seated?
Yes, sir.
Seat 2.
Response?
Stipulate.
Juror in seat 2 wearing badge 651 will be stricken for cause by way of stipulation.
Seat 22.
Stipulate.
Juror in seat 22 wearing badge 13 will be stricken for cause by way of stipulation.
Seat 34.
I'm sorry?
34.
Stipulate.
Juror in seat 34 wearing badge 310 will be stricken for cause by way of stipulation.
Seat 44.
Stipulate.
Juror in seat 44 wearing badge 506 will be stricken for cause by way of stipulation.
Seat 48.
Stipulate.
Juror in seat 48 wearing badge 4045 will be stricken for cause by way of stipulation.
No additionals.
Any additional cause challenges on behalf of the defense?
No, Your Honor.
Okay, all right. I believe that leaves us with 38 potential jurors remaining, if my math is correct. We will begin with selection at this point in time, starting with seat number 1. State, acceptable?
Judge, excuse me. Can we make some seating arrangements because I have to receive because I'm
Sure.
gonna have to.
If you need to move, go ahead, sir.
Yeah. Judge, we're ready.
All right, starting with seat number 1. State, acceptable?
Acceptable.
Defense?
Acceptable.
Seat number 2 was previously struck for cause by way of stipulation. 3. State?
Acceptable.
Defense? 4. Defense? State?
First peremptory.
Any response, defense? Any response to the peremptory challenge as to juror in seat 4? So stricken. Seat 5.
Acceptable.
Defense? 6. Defense?
Acceptable.
State?
Acceptable.
7. State?
Acceptable.
Defense? Any response, state?
No, sir.
That will be juror number 7 wearing badge 380 will be struck by virtue of the defense's first peremptory. 8. Defense? State?
Second peremptory.
Any response?
None.
Juror in seat 8 wearing badge 361 will be struck by virtue of the state's second preemptory. 9, state.
Acceptable. I'm sorry, acceptable.
That's fine. Appreciate you. Defense?
Acceptable.
10. 10 and 11 were previously struck by way of stipulation for cause. 12, defense. Any response?
No, sir.
Juror in seat 12 wearing badge 837 has been struck by virtue of the defense's second preemptory. 13, state.
Acceptable.
Defense?
Acceptable.
I believe that we have a panel. Our panel currently is jurors in seats 1, 3, 5, 6, 9, and 13. Any backstrikes? State.
Seat 6.
Any response?
No response.
Juror in seat 6 will be struck by virtue of the state's third preemptory. Any additional backstrikes? State.
No, sir.
Any additional backstrikes? Defense.
No, Your Honor.
Picking up on 14. Defense. Any response?
No, sir. So that's alternate strike 1.
We don't have a panel, sir.
Oh, I thought we said.
No, we had 6. Currently of 1, 3, 5, 9, and 13.
Acceptable. Sorry, no objection to their peremptory. I guess that's.
Juror number 14, wearing badge 537, will be struck by virtue of the defense's third preemptory challenge. 15, state.
Acceptable.
Defense.
Acceptable.
Believe that we have a panel. Our panel currently is 1, 3, 5, 9, 13, and 15. Any backstrikes? State.
No, sir.
Any backstrikes? Defense.
Need to confer with my client.
You may.
Judge, at this time, the defense would like to use a peremptory on juror number 1.
Any response? State.
No, Your Honor.
Juror in seat 1, wearing badge 134, has been struck by virtue of the defense's fourth preemptory. Any other additional backstrikes?
No, Your Honor.
Any additional backstrikes? State.
No, sir.
All right, picking up with 16. Defense.
Acceptable.
State.
Acceptable.
I believe we have a panel. Panel is 3, 5, 9, 13, 15, and 16. Any backstrikes? State.
No, sir.
Any backstrikes? Defense.
Judge, could you read the panel?
I can, sir. 3, 5, 9, 13, 15, 16. Yes, sir. Of course. Any response? State.
No, sir.
Juror number 3, wearing badge 899, has been struck by virtue of the defense's 5th preemptory. Any other additional backstrikes? Defense.
No, Your Honor.
State. Yes, sir.
How many strikes do you have the defense?
You've used 5. Any other additional backstrikes? State.
No, Your Honor.
Picking up on 17. State.
Acceptable.
Defense.
Acceptable.
I believe we have a panel again. Jurors 5. Yes, sir.
I need to go back on 17, so we are going to use a preempt on juror 17.
Any response?
No, sir.
Juror in seat 17, wearing badge 57, will be struck by virtue of the defense's 6th preemptory challenge. 18. Defense. State.
4th peremptory.
Any response? Defense.
None.
Juror number 18, wearing badge 7, struck by virtue of the state's 4th preemptory challenge. 19. State.
Acceptable.
Defense.
Preempt.
Any response?
No, sir.
Juror number 19, wearing badge 891, will be struck by virtue of the defense's 7th preemptory. 20 was previously struck for cause. 21.
Acceptable.
Believe that we have a panel. Panel is 5, 9, 13, 15, 16, 21. Any backstrikes? State.
No, sir.
Any backstrikes? Defense. The first, of course. Okay. Our jury panel will be jurors seats 5, 9, 13, 15, 16, and 21. We will now proceed with selecting any alternates. Yes, sir.
Could you announce the jury?
I can't, sir. 5, 9, 13, 15, 16, 21. Thank you. Juror number 22 was previously struck for cause. 23 for an alternate position. State.
Acceptable.
Okay. Juror number 23 will be serving as our first alternate. Moving to juror in seat 24. Defense. Any response?
No, sir.
Juror number 24, wearing badge 235, will be stricken by virtue of the defense's 8th preemptory challenge. 25 was previously struck for cause. 26. Defense.
I have a question on the process. We're at the alternates now.
Correct, sir.
So at this point in time, it starts over because we have alternate challenges. Is that correct?
Yeah, the way I marked his down was as defense alternate 2 strike, just because it was our second alternate, but we should have as many alternate strikes as we seat alternates is what I believe our agreement is.
All right, that's fine by me. All right.
I thought I only have one alternate strike.
Well, but I just marked it as, because we're shooting for alternate number 2, so I'm just trying to keep track of that but.
I understand what you're saying. So I've used one alternate strike.
Yes, sir.
That's correct.
All right, I'm ready.
25 was previously struck for cause. 26. Defense. Any response?
No, sir.
26, wearing badge 165, will be the defense's second alternate preemptory. '27, State.
Acceptable.
Defense.
Acceptable.
Juror number 27 will be our second alternate. 28. Defense.
Acceptable.
State. Acceptable. Juror number 28 will be our third alternate. 29.
Acceptable.
That's the state's call. It's odd.
I'll use an alternate strike.
Any response, defense?
No response.
Juror number 29 will be struck by virtue of the state's first alternate strike. 30 was previously struck for cause by way of stipulation. 31, state.
Acceptable.
Defense? Any response?
No, sir.
Juror number 31 will be struck by virtue of the defense's third alternative strike. 32, defense.
Acceptable.
Acceptable.
32 will serve as our fourth alternate. 33.
Who's it on?
State. It's odd.
Acceptable.
Defense?
Acceptable.
All right, 33 will serve as our sixth alternate.
Fifth.
I'm sorry, I'm one ahead. I already wrote it in for 5. I apologize. 34 was previously struck for cause. 35. State.
Acceptable.
Defense.
Acceptable.
Juror 35 will be our sixth alternate. 36, defense.
No response.
Juror in seat 36 will be struck by virtue of the defense's fourth alternate strike. 37.
Acceptable.
Defense.
Acceptable.
37 will serve as our seventh alternate. 38. Defense.
Acceptable.
State.
Acceptable.
We have an alternate panel, a total of 14. Our alternates are 23, 27, 28, 32, 33, 35, 37, and 38. Any back strikes, state.
Seat 35, alternate strike number 2 for the state.
Any response?
I mean, I'm not 30. Did I say 35?
You said 35, yes, sir.
33.
Okay.
No response.
All right. Juror in seat 33 will be the state's second alternate strike. Any additional back strikes, state.
Not at this time.
Any additional back strikes, defense.
No.
39 and 40 were previously struck for cause by stipulation. 41, state.
Acceptable.
Any response?
No, sir.
All right, juror number 41, wearing badge 76, has been struck by virtue of the defense's fifth alternate challenge. 42 was previously struck for cause by way of stipulation. 43, state.
Acceptable.
Defense.
Acceptable.
I believe that we have our alternates. Our alternates at this time are 23, 27, 28, 32, 35, 37, 38, and 43. Any back strikes, state.
No back strikes to the original panel or the 8 alternates.
Defense. Any back strikes? Yes, sir.
Judge, we're satisfied as to both the original panel and alternate.
Okay. So our alternates in this case will be juror in seat 23, 27, 28, 32, 35, 37, 38, and 43.
State accepts the panel.
Defense, do you accept the panel? Yes, sir. Okay, very good. Can the parties approach for a moment? Ms. Boone, good afternoon, ma'am. I have a couple of things to go over with you before we bring in our panel. You were previously sworn this morning. You've been present throughout the entire jury selection process that began on Monday. You've been seated at counsel's table either here in 23 Alpha or 12 Alpha of the Orange County Courthouse, and you've been able to observe the jurors during that entire process. Were you able to hear the questions asked of the jurors and their responses?
Yes.
Did you confer with your counsel about who you wanted or did not want to be selected for your jury?
I did.
Do you believe you were given a meaningful opportunity to participate?
Yes.
Is there anyone that you wanted to keep that your lawyers struck?
No.
Are you satisfied with your attorney's performances so far in this trial?
Absolutely.
Do you agree with the panel that has been selected for your case?
Absolutely.
Is there anything you would like to bring to my attention at this time?
No, thank you very much.
When the court reads the 2.1 preliminary instruction, defense, would you like me to read the defendant's right to remain silent section of same to our panel?
Yeah, sure.
All right, thank you very much. Bring our panel in. State.
No, Your Honor.
Defense.
No, Your Honor.
Okay. Let's go ahead and bring back in our panel. We will stand. Madam Clerk will identify them by their badge number. I will ask them to remain seated where they are, and then we'll excuse the balance of the panel. I will give them an instruction. Court will then read the 2.1 instruction and 2.1a note-taking instruction and provide explanation for where we will be tomorrow morning. So let's go ahead and stand and bring in our panel. Do you have a blue pen? I only have black. Thank you.
certificates ready downstairs and send them back to her.
Thank you. State, do you recognize our panel?
Yes, sir.
Defense, do you recognize our panel?
Yes, Your Honor.
I thank you. All can be seated. Members of our panel, we have been able to select a jury to serve in this case. Madam Clerk is going to call you out by your badge number, not the paddle number that you've been using all yesterday and today. Please stay in your seats when your badge number is called. Madam Clerk?
Juror number 295. Juror number, you want them to stand? So.
Please, if you could stand when your name is your badge number is called, please. Thank you.
Juror number 9. Remain standing. Juror number 569. Juror number 515. Juror number 130. Juror number 249. 249. Juror number 448. Juror number 110. Juror number 306. Juror number 33. Juror number 519. Juror number 2130. Juror number 413. And juror number 102.
State, do you recognize the jury is selected?
Yes, Your Honor.
Defense, do you recognize the jury is selected? Bless you.
Yes, I do, Your Honor.
All right. Thank you. You all can be seated. Thank you very much. To the members of our panel that were not selected, I thank you so much for your time and your participation and your attention in this very important process. You have my thanks, the thanks of the lawyers, and the thanks of Ms. Boone. It is entirely up to you whether or not you would like to discuss this case. You may do so, or you may decline. That privilege is yours. Please proceed now back to the jury assembly room, where they will validate your parking, provide you your jury certificates, and give you further directions. Thank you, God bless you, and have a great rest of the week. Please don't go anywhere. Mary, do roll call one more time. Okay. Please.
I'm just going to do a roll call.
Y'all can be seated. Thank you.
Just going to do a roll call. You don't have to stand. Just raise your hand. Juror number 295. Juror number 9. Juror number 569. Juror number 515. Juror number 130. Juror number 249. Juror number 448. Juror number 110. Juror number 306. Juror number 33. Juror number 519. Juror number 2130. Juror number 413. Juror number 102.
All right, thank you. All right, members of our jury, I have a couple of instructions to read to you. Oh, yes. Madam Clerk needs to swear you in. So if you could please stand up and raise your hands, please.
Do you swear or affirm to truly try the issues between the state of Florida and the defense and render a true verdict according to the law and evidence, so help you God?
Thank you all very much. You can be seated. Ladies and gentlemen of the jury, you've been selected and sworn as the jury to try the case of the state of Florida versus Sarah Boone. This is a criminal case. Ms. Boone is charged with murder. The definition of the crime charged will be explained to you later. The state's charging document, which is called an information, is not evidence, and it is not to be considered by you as proof of any guilt. It is the judge's responsibility to explain the law to you. It is your solemn responsibility to determine if the state proved its accusations beyond a reasonable doubt against Ms. Boone in accordance with the law that I provide to you. Thus, the province of the jury and the province of the court are well defined, and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits may also be produced as evidence. After the evidence has been presented, the court will give you instructions on the law. The attorneys will then have the opportunity to make closing arguments. Following the closing arguments by the attorneys, the court will conclude with the final instructions. After the final instructions are given, you will then retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all of the evidence, the argument of the lawyers, and the instructions on the law by the judge. Until that time, you should not discuss the case amongst yourselves. Your verdict must be based solely on the evidence or lack of evidence and the law. I now instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of any of these rules at all, notify court personnel of the violation. During the course of the trial, the court may take recesses, and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about this case, tell him or her that you are on the jury trying the case and ask that person to stop. If he or she persists, leave that person at once and immediately report the matter to the court deputy, who will advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you are in the courtroom. Turned off means that the phone or other electronic device is actually off and not in a silent or vibrating mode. You may use these devices during recesses, but even then, you may not use your cell phone or electronic device to find out any information about the case or communicate with anyone about the case or the people involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, please double check to make sure your cell phone or electronic device is turned off. End of the case, while you are deliberating, you must not communicate with anyone outside the jury room. You cannot have in the jury room any cell phones, computers, or other electronic devices. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. A contact phone number will be provided to you. The case must be tried by you only on the evidence presented during the trial, in your presence, and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation on their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. So do not let even the closest family members make comments to you or ask questions about the trial. In this age of electronic communication, I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, the trial judge has no way to make sure that the information you obtain is proper for the case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. This is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it, and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result, which would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions, such as serving time in jail, paying a fine, or both. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove her innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it was made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. During the trial, it may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences occur, they will be conducted as so to consume as little of your time as necessary for a fair and orderly trial of the case. Members of our jury have one additional instruction to read to you regarding note-taking. If you would like to take notes during the trial, you may do so. On the other hand, of course, you are not required to take notes if you do not want to. That will be left up to you individually. You will be provided with a notepad and pen for your use if you wish to take notes. Any notes that you take will be for your personal use. However, you should not take them with you from the courtroom. During recesses, the court deputy will take possession of your notes and will return them to you when we reconvene. After you have completed your deliberations, the court deputy will deliver your notes to me. They will be destroyed. No one will ever read your notes. If you take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. With that, members of the jury, we will pick up tomorrow morning in courtroom 12A of the Orange County Courthouse, and we will begin with opening statements at that time. I instruct you to follow the instructions that I've just read to you, including not reading any newspapers or watching the local news, having any conversations with anyone, or conducting any independent research or investigation as to the persons, places, things in charge in this case. With that, again, I thank you for your service, and we will see you in 12 Alpha tomorrow morning at 9 a.m. May the parties approach for one moment. Mr. Owens, once you've had that conversation with her, just let me know.
If I may. I've conferred with my client about the issue on cross-examination of her ex-husband, Brian Boone, about the family law case, the dissolution of marriage case. And through my cross, if I explore those issues, it may come out that she's been in jail pending her arrest back in February the 24th of 2020, so 4.5 years. She understands that may open the door. It may come out. She understands that I have to make a decision about whether to explore that area of cross-examination, but I believe she's going to say that she trusts my judgment. She is concerned about it coming out that she's had 8 prior attorneys. She does not want that coming out, but that's her biggest concern.
Okay, we'll address that in just a moment. Ma'am, I don't want to go into the specifics of any conversation you've had with any of your attorneys on that issue. I just need to know whether or not you've had those conversations, okay? Is what your lawyer just represented accurate as the conversation that you've had as to that issue regarding cross-examining your former husband, Brian Boone?
Yes.
Okay. Do you understand the risks that if he seeks to impeach or call into question the bias and credibility of your former husband, Mr. Boone, as to what has transpired in your dissolution of marriage case, it may open the door to the fact that you have been incarcerated since February of 2020?
Yes.
Are you in agreement with that strategy, understanding those risks?
I am.
Okay. Now, with regard to your concern, ma'am, over having 8 prior attorneys, I don't intend on allowing it. I'm sure that's not part of the state's case in chief.
No, Your Honor, I don't see how it would possibly become relevant, but if we somehow believed it did, we would certainly have a sidebar before anything about that.
If, by some circumstance, that somehow becomes relevant, I'm going to ask the state to approach before we even get near addressing that issue in front of our jury. Okay? Ma'am, do you have any other questions for me at this time?
I do not.
All right. State, anything further?
No, sir.
Defense, anything further?
No, sir.
All right, we will see you all tomorrow morning at 9 a.m. The court will conduct its regular docket at 8:30. Thank you. We're off the record.